This case is important because the Supreme Court has called schools nurseries of democracy. We expect our public schools to prepare the next generation of Americans. And it has been part of American culture since the founding to criticize and satirize those in power. And it teaches a very dangerous lesson to kids about what America and our Constitution is about if they're taught from a young age that if they criticize or satirize somebody in power, that they can get in trouble for it. That is not what the First Amendment is about, and it is not what the Constitution is about. My name is Connor Fitzpatrick. I am an attorney at the Foundation for Individual Rights and Expression. So last year, a high school student at Tullahoma High School posted 3 memes on his personal Instagram page satirizing the principal. The memes were very tame. They did not threaten anyone. They did not contain any bad words. But what they did do is poke fun at the principal's overly serious nature. The first meme showed the principal holding a box of vegetables. The second showed the principal in a dress with cat whiskers and cat ears. And the third showed the principal being hugged by a cartoon bird. And in retaliation for posting those memes, the school suspended the student for 3 days. And that's a violation of the First Amendment. The school claimed to be relying on a student policy that prohibits students from posting anything online which embarrasses, demeans, or discredits someone else. But the problem with that is posting content which embarrasses or discredits a government official is protected by the First Amendment. It has been for over 200 years. And more than that, it's a vague policy. A video of the high school quarterback throwing an interception might embarrass or discredit them. Surely the school isn't going to prohibit that. And the danger with vague policies is that those in power use it to suppress criticism. There are 2 primary Supreme Court cases that will govern this case. The first is Tinker versus Des Moines from the late 1960s. Tinker involved middle school students who wanted to wear black armbands to school to protest the Vietnam War. And the Supreme Court held that as long as a student's expression does not substantially disrupt the school day, the First Amendment protects their right to make their voices heard. And the second case that governs this particular dispute is a case called Mahanoy, and it's from 2021. That dealt with a Snapchat post by a high school student who was unhappy that she didn't make the varsity cheerleading team. And when she didn't, she posted a couple of snaps to Snapchat saying a few bad words about the cheerleading team and the school. And what the Supreme Court held is that based on Tinker, because her Snapchats did not cause any disruption at school, the school had no business punishing her for her private expression on her own time. And that's the case here. The student posted these Instagram memes on his own time, 2 of them during summer vacation away from school, and they did not disrupt school. In order for a school to be able to punish a student for their expression, it has to meet a very high bar. It has to substantially disrupt the school day. And the cases that have interpreted that standard have found that what's necessary is something like a direct threat or sexual threat against another teacher or another student, something that tangibly impacts the school day or could tangibly impact the school day in a severe manner, like threatening the school's safety, like threatening violence. Nothing like that is present here. These are peaceful, playful Instagram memes showing the principal holding vegetables and being hugged by a cartoon bird. They aren't threats. They're nowhere near what courts have held is required in order for the school to censor it. We feel comfortable that these memes are squarely protected by the First Amendment because they occurred outside of campus, did not disrupt the school day, and the school has never claimed otherwise.